Now, Aline, another argument that I've heard in favor of public interest standing is that it allows organizations to challenge and even strike down a law as unconstitutional before it actually hurts someone. So can you give me an example of that? And can you expand on why that part of the role of public interest litigants might be so important?
Yeah, so public interest standing could assist in that way if you have a law that on its face is going to be harmful, detrimental, unconstitutional towards a group of people. And it could assist in a court seeing that before the harm happens, something should be done. The difficulty with making that kind of claim is that you don't readily have a record for the harms that the law is going to achieve. But when you have public interest standing, what you can do is you can have an organization step in and say, look at what has happened. Let's not let this ever happen again. Solitary confinement is an example. Should we be imposing that kind of a stricture on individuals ever again? Public interest standing could allow you to intercede before further harm happens.
Really excellent point. Now, Mark, one of the government's arguments in favor of, narrowing the accessibility of public interest standing is that they had concerns over what they called litigating hypotheticals. They argued challenges need to be grounded in facts. So how do you respond to that concern from the government?
Well, it's a long-held judicial philosophy that cases should be decided on real facts, and I'm sympathetic to the idea. Where the pea goes under the shell a bit for the government is this idea that everything's about hypotheticals, when really what you have in this case and many other cases is very real facts. What you don't have is a plaintiff who's experienced them, but you may have many other witnesses or other individuals or indirect knowledge. For example, a physician may be able to testify instead of an actual affected a person in the mental health system who can give those real world facts. So to me, it's there's they use it as a specter to scare the judiciary into thinking, oh, we really need to narrow this test, or it's going to floodgate the courts with these problem cases.
Aline, do you want to respond to that as well, to that concern the government raised about litigating hypotheticals in this floodgate argument?
Yeah, I think Mark is quite right. The principle of needing adjudicative facts, which are the who, what, why, where, how of the situation, is longstanding, and it sets up the adversarial process, right? Like, what are we fighting about? But the reality of the situation is, when you're talking about is a law unconstitutional, you're not talking about is it about unconstitutional against one person, really. You're talking about what kind of set of problematic effects does it have, and how is that going to play out on the ground in a number of ways. So is it important for me, individual, to tell you my facts as plaintiff, or is it important for me, individual, to give you that evidence as a witness alongside an expert, alongside a government report, and a range of information? So the hypothetical cases and plaintiff-less litigation, it's just not a real thing that happens in these kinds of cases.
Now, the case was heard at the Supreme Court. Mark, how long do you think it's going to take to get a result? We've only got about 20 seconds left.
3 to 5 months.
5 months. Okay. Alan, do you have a guess on the timeline here?
Is it Price is Right rules? Like you can't go over? I think that's a good bet. 6 months, maybe.
Okay. All right. Well, I want to thank you both so much for joining me today and for the important work that you both do working with public interest organizations. I really appreciate it.